Please step up to the microphone. Begin by going through the trial list. Richard Stebbins, scheduled for jury trial.
Morning.
Good morning, Your Honor. Lindsay White for the Commonwealth.
Okay, so let me just check here. So you represent the Commonwealth. Do you have a lawyer, sir, or are you representing yourself?
I'm representing myself.
Okay, all right, let's hear from the prosecutor. Looks like it's on for jury trial. Okay, what's the prosecutor's position on this one?
Your Honor, I did speak to Mr. Stebbins. We did agree on a date of 10/15 for a jury trial.
For jury trial? Okay. We don't have forums today for a jury trial, so is discovery all complete?
Yes, Your Honor.
Case has been going on for a while, so I would assume so. Okay, so 10:15. Tuesday 10:15 looks good. Okay. All right, so October 15 for jury trial. So, sir, if you're representing yourself, you need to talk to the prosecutor. I don't know if you've conferenced the case, so you know what to expect, who the witnesses are, things like that. I always say this to people. When I take a look at the charge and I say, I'm going to say this. A lot of people would say with charges like this, it'd be a very good idea to have a lawyer who knows the rules of evidence. You can make your own decision. I see the case has been going on for a long time. I just feel I have an obligation to let you know that with a charge like this, a lot of people would say it'd be a good idea to have a lawyer, knows how to negotiate with the prosecutor, get evidence into a trial, things like that.
I had 4 lawyers appointed to me, and I requested evidence, and I did this in email form, and it never happened. I'm still going to go to trial without this evidence because I'm going to use that as part of my case.
Don't go to trial without evidence. And the trial's getting. Hold on a minute. The trial's getting continued until October, so there's plenty of time to get whatever evidence it is you think you're entitled to. What is the evidence that you think?
I'm sorry, Your Honor.
What is the evidence that you think you don't have?
I have emails that I sent on Miss Nichols' behalf.
What
that she had in her possession when I had left. These
emails to the
about her son, about the treatment of her son,
so
about her mental state.
Emails that you sent.
Yes, on her behalf, and she had these saved for legal proceedings.
So have you
in the
talked
future.
Have you talked to the prosecutor about that evidence? I don't know anything about the case, so I can't get into too much detail about it. But have you talked about that particular issue, Commonwealth? Emails.
I have received evidence from Mr. Stebbins. So.
Well, he's talking about, it sounds like, evidence to him, given to him. Is that what you're talking about, sir?
I believe it's Rule 17, a third-party information. Ms. Nichols was saying.
So what, sir, this is the thing. When you have a lawyer knows how to streamline it, knows how to make it understandable to me. Is it evidence? Is it evidence? Sir, hold on a minute. Another thing a lawyer knows is you don't interrupt the judge. Okay. So, do you have evidence you're looking to get from the prosecutor? Yes or no?
Yes.
Okay. So, have you talked to her recently about what that evidence is?
No.
So, I'm going to have you step into the hallway, talk to the prosecutor, clarify what evidence it is. If there's a dispute, Commonwealth, you don't, of course, just because you want it, sir, doesn't mean you're legally entitled to it. A lawyer would know what that is. I'm going to have you talk to the prosecutor in the hallway.
I don't want it. The court date is fine. I don't want the information.
No, sir. You cannot come back on the next time and say I didn't get the evidence. This is how we do it. You talk before the court date to clarify what evidence is that you say that you need. So I'm going to have you step into the hallway, talk to the prosecutor. We'll call the case again quickly and get you out of here. But this is how we do it, sir. There's no trial by ambush. And the way to get it is to talk about it before the trial date.
And I'm going to have to record this conversation with the district attorney in the hallway. I've had this conversation with my previous lawyers.
Go to the hallway, sir, and talk to the prosecutor, and she's going to come back and report on what evidence is that is outstanding or is in dispute. All right?
Richard Stebbins, scheduled for jury trial.
Okay. So on this case, you're talking about having outstanding discovery issues. So, were you able to talk to the prosecutor about that?
No.
Okay. Commonwealth, what can you report on that?
Your Honor, I was unable to speak to Mr. Stebbins on that matter. I think I am aware of what he is asking for.
Well, let me ask you: is there a reason why you're unable to talk to him? Is there?
He was trying. He asked to record the conversation, and I declined.
And you don't want to do that? right? Okay. So and is that the case, sir? The only way you'll talk to her is if you can record the conversation?
I'm sorry, but I was supposed to have trial today.
Yep.
So if
So
I
here's
had
the
trial
thing.
today, this evidence I asked for 2.5 years ago, I would have went to trial without it.
Okay.
So I'll
Sir.
go to trial without this evidence. She
right.
knows about the evidence.
Here's the
and
thing,
she doesn't
sir.
want to gather it. That's fine.
No. First of all, nobody's having a trial today, sir. There's limited forums, courtrooms, so it's not just you. There's a number of other trials. We just continued, and we're going to be continuing some other ones. It's nothing to do with you personally or your case. Wait, let me finish, okay? So nobody's having a trial today, including you. It's not personal to you
I
or the
understand
prosecutor or this case. So let me just tell you that part. Now, in terms of, in every criminal case, we try to make sure that discovery is resolved, meaning the information the prosecutor is going to give to you. There shouldn't be trial by surprise. We don't do trial by surprise in Massachusetts. If the prosecutor wants to introduce evidence against you, she lets you know. If you want to introduce evidence against her, you let her know. So you told me this morning that you had some issue. There's outstanding discovery. You're entitled to it if it's under the rules of criminal procedure and case law. If you're entitled to it, I will order the prosecutor to provide it to you if you're entitled to it. So I don't know what the issues are. I see a very old pretrial conference report in the case. So it sounds like today you're not able to talk together today in person while you're here in court. She doesn't have to agree to be recorded. And if that's your rule for today, then she doesn't have to agree to that. I'm not going to order her to allow you to record her. So what I am going to do, sir, in terms of discovery is this. All right. So you're ready to pick a trial date. Is that right? Everyone thinks you pick a trial date. So let's start with that. What date can you agree on for a trial?
October 15th, Your Honor.
Okay. That's a day you're agreed to, sir?
If that's the soonest there is, that's what I'm stuck
Okay. So let me look to make sure we don't have too many other cases on that day. Day of the week is October 13th. I have Tuesday being the 15th.
It was October 15th, Your Honor.
Oh, 15. Okay. Yes, the 15th. Yes, that's a good day for the court. So that's going to be the jury trial day, if that's what you want, sir, a jury trial, not a bench trial. We're going to do, though, in terms of discovery, is this. I'm going to give you 10 days, sir. So we're going to write this down for you also. You're going to have 10 days from today. So today's August 5th. That's going to give you 2, 3, 4. You're going to have till August 15. We're going to write this down for you if we could, to our court officer. Thank you very much. You have till August 15th to request in writing to the prosecutor the information that you think you're entitled to. Okay? So she's going to give you, before you leave today, her contact information. You can deliver it, hand deliver it to the office to her. You can mail it to her. She's going to give you her address, so that you have that information about where you're going to request whatever information you think that you're entitled to, okay? Now, I urge you to look at the rules of criminal procedure and all case law to determine what, in fact, just because you want it doesn't mean she has to give it to you. It may not be in her custody and control. If she doesn't have it, she doesn't have to go out and get it, okay? Now, the Commonwealth is going to have 10 days after that to respond. So the Commonwealth, you're going to have until, say, the 26th, because that's a Monday, okay? August 26th, the Commonwealth has to provide whatever answer that she has in writing. She's going to provide it in writing, okay? You're both going to do this in writing, so that's how we're going to record, take notes, so there's no confusion about what you're asking for and what she's agreeing to. And then we're going to pick a date sometime after that you're going to come to court. Both of you are going to come to court for a final trial assignment date, just to make sure that all discovery issues are complete. So there's because she may feel she doesn't have to give you the discovery, and it may be that a judge would disagree. So just like any other defendant, you ask the prosecutor, she gives you what she thinks she's supposed to give you. And if you think she isn't giving you what you're entitled to, you can ask the judge. So Commonwealth, I'm going to ask you to suggest a date in a time frame, sir.
I'm sorry, but what you just said was everything I disagreed with the previous lawyers I had about, and this district attorney. Like, this information.
Hold on a minute, sir. This is what we're doing. This is the process. Let's pick a date. So that's going to be after the 26th. It's going to be, let's say, sometime the first or second week of September. It's going to be for a final trial. Then you get a date that's going to come in and clarify once and for all whether you have a, sir, if you haven't requested it, I should make this clear. If you haven't requested it in that next 10 days, if you don't request it, you're not entitled to it. Discovery is done. Discovery is finished. If you don't ask for it, you don't write it down and ask the prosecutor for it, your time to ask for it is done. This case has been going on a long time. So, Commonwealth, what date would you suggest in that time frame? We'll make sure it's a day okay for him.
September 9th, Your Honor.
September 9. All right. It's a Monday. That day is good for you as any other day, sir, to come to court?
Zoom? Is there a reason I have to
No, you should
physically
come in
be-
person, sir, because that helps resolve the issues. Okay?
That's fine, then I'll be
September
here.
9. Okay, September 9 then is an in-court event. That's the trial assignment date. Okay, so you need to come to court September 9 to address and just make sure that all the discovery has been addressed. That's not a time for you to ask for a new item, sir. You've got 10 days from today. Anything you haven't asked for by August 15, you are foreclosed, prevented from asking for any future information about. Okay? So we're going to wrap up, close out discovery on this case. August 15, by August 15, you got to send it to her so she can respond. She's going to respond in writing. If you're disagreeing, Commonwealth, you need to respond in writing. I do not feel I need to have that. I don't have that. Whatever your response is, do it in writing so he gets it. This is the way you guys are going to communicate. Okay? And then we're going to see you both here September 9, 8:45 in the morning to make sure all discovery is all set. If there's any disputes, if you think you're entitled to something that she hasn't provided you by that date, you can argue it to a judge. And one way or the other, we'll see you for trial on that October date.
Thank you.
Okay? Commonwealth have any questions?
No, Your Honor.
Sir, do you have any questions?
No, Your Honor.
Okay. We'll see you back here September 9. Thank you. Let me write those down in the